The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome, counsel, and also to those who are watching on our live stream. At this time, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the next case on the docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, February 3rd, 2022 consists of two cases. First case heard on the docket is appeal number 122163, State of Kansas versus Jeff Hillard. Sedgwick County briefed both sides. Immediately following will be the second case, appeal number 124397, in the matter of Michael M. Spiegel, matter and attorney discipline. Your Honor, the appellant in State v. Hillard, 122163, has reserved 2 minutes rebuttal. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, appellant Jeff Hillard appears by counsel Wendy Miller.
And may it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel. Ms. Miller, you may begin your argument.
Thank you. I'd like to start the arguments with some of the suppression issues because I believe that might be what is different about the co-defendant's brief. I understand some of the issues that we've raised have been ruled on in Ms. Hillard's brief. But first, we start out with the entry into the residence. And law enforcement on the day of events here had received a 911 call from Shirley Grunder, who had observed a fist fight outside of a residence on Meridian in Sedgwick County. She said that her son was involved and some others, that they beat a man up outside of the residence and then left in a truck. So officers also received a call from a Mr. Bright, which was the brother-in-law to Mr. Hillard, who had indicated that Mr. Hillard had stopped by his home, had asked him for some cleaning supplies, had made some reference to needing to stash something. And so that's the information law enforcement had. They indicated they needed to enter the residence to check on the welfare of any other persons that might need assistance. However, based on Ms. Grunder's call, the information they had at the time was that there had been a fight outside this residence and that the participants of that fight had left. There wasn't any reason to believe that anybody was armed, that law enforcement was somehow in danger or that there were any other participants. So law enforcement entered the home. They brought out
Counsel?
Yes.
I'm sorry to interrupt you, but before you get too far down in that timeline, I thought Ms. Grunder had reported that there were up to 6 individuals on the property. And while she did note that her son and another and the victim had left the scene, I don't remember, and I don't believe the district court, did the district court make any findings about the other individuals that Ms. Grunder reported being on the scene?
I will stand on what's in the record factually. I am not aware of any kind of report that anybody entered the residence. My understanding is that what she observed occurred outside of the residence and that her son and others that had been involved in the fight then entered her son's pickup and left. Now, if there were other people there that left in separate vehicles, I'm not aware of that, but I'll stand by the record. So once law enforcement entered the residence. They had entered into the garage and looked at surveillance video. I think they messed with a mouse and tried to find something on the surveillance system that was in the garage. And I'm not sure that they were able to do that with that particular system. And so the persons that they had found in the house, Miss Hillard, I believe it was Miss S, and then 2 young girls were brought out and separated. At that point, they were waiting for a search warrant. But our position is that the entry into the home was not justified by the emergency exception, because there was no indication that anybody inside the house needed help, or that there was anybody inside the house. What they had was the fight that occurred outside the house. And then there was no reports of anybody being armed, just that somebody had been beaten up, put in a truck, and they left. So after the entry issue, and the trial court found that they could check for anybody else that might be hurt, that there was a bloody scene outside. But our position is that what they had reported had occurred outside. What the 911 caller, Ms. Grunder, had reported occurred outside. No reason to enter the home, and no reason to start rummaging through the surveillance equipment, which is a second one of our suppression issues, is the entry into the bedroom and then looking at the surveillance equipment, and then confirming, I think, through their search of it, that Mrs. Grunder had reported what she saw outside is what they were able to confirm when they looked at that. At that point, I believe that they had been told, when they looked at the surveillance equipment in the bedroom, that they had been told that the search warrant was approved for the home. But I don't believe that the search warrant for the surveillance equipment had been approved yet. And then also, in looking at the search warrant for the surveillance equipment, it doesn't contain facts to support a search of the surveillance equipment. It generally states words to the effect that they know that surveillance equipment can record events, but there's nothing other than that general statement to support the warrant. But the problem is that it was searched before the warrant was approved. And then with the phones that were seized, I believe the warrant that had allowed officers to go into the home had indicated that they could also seize cell phones and recording equipment, surveillance equipment, as fruits of the crime. But again, aside from the general assertion that these types of equipment can record events, there was nothing specific factually to support that these recording devices had anything on them. Nobody had indicated in the 911 call that there was a cell phone involved. None of the witnesses had indicated that to them at the time that they had seized this equipment. Then with the cell phones, they had not had permission to look inside the phone. They had the first warrant that said that it's okay to seize the phone, but then they didn't get a warrant that specifically said what they could look for on this phone, or that they could search it for any particular item, what they could include, what they could exclude, what kind of files, and what information they had that supported probable cause to do so. And we know from Riley v. California that a search of a cell phone requires a search warrant, but it also needs to be specific. What are you looking for and why? And that was omitted in their search warrants. With the first seizure, it was a couple of days after the events that were observed by Miss Grunder. Law enforcement, and I believe it might have been Detective Noel, looked at the phone and manipulated the phone and began to unlock it from a locked position. And I don't believe he was able to observe much, but he had manipulated the phone, and trial counsel had argued that he had moved that phone from a position of being on or being off to on. And then he wasn't able, apparently the phone was locked. There were two phones. One was appellant Hillard's phone, and the other phone was his wife, co-defendant Heidi's phone. And so law enforcement didn't have a way to unlock it. So 10 months go by, and then law enforcement receives an email from a private company in New Jersey saying, hey, we've got some technology that we can bypass codes where we can get into a locked phone and bypass the codes and search that phone. So 10 months after events, law enforcement applies for a search warrant to search the phone. Again, there was nothing specific, no additional information about the cell phone, how it might have been involved in any of the offenses that was alleged in the search warrant. So the search warrant was approved. Detective Noel flew to New Jersey, handed off the phones, and then one was unable to be unlocked, I believe. This is very fact intensive, so I rely on the record as it's stated in transcripts and the hearings. But one phone, which was believed to be Mr. Hillard's phone, was unlocked, and the entire phone was rummaged through. Files were pulled up. The search warrant didn't exclude any kind of information from the phone. It just kind of authorized a general, search the phone and pull up all the files. But there was no limitation by date or time, or by what kind of content they should be seeking, videos, what kind of audio files, nothing. And then part of what's complicated about the searches of the iPhones is that then there were 3 recordings that were taken from Mr. Hillard's phone. And those 3 recordings were admitted at trial. One was a depiction of, or was events from something that occurred in a car. And one was events that occurred outside the residence. And then there was a 3rd recording of events. But the problem with the recordings was that it wasn't all discernible. When the detective listened to it, he did not have a certified court reporter transcribe those recordings. He had witnesses, Miss SS, as she's referred to in our brief, and then Mr. Bussart, who had taken a plea in this case, testified against the Hillards. They had taken these recordings and had both of those witnesses who testified against the Hillards describe who was saying what, whose voice was being heard, because there was talking over each other. And then more problematically, then the recordings were enhanced by Lawrence Police Department, which trial counsel had objected to that enhancement. But the problem with the iPhones and the evidence obtained from the iPhones is significant. There's a lot of problems with it. One being the lack of probable cause, the lack of anything specific to search for, just the general take everything on the phone and grab it.
Counsel,
Yes.
on that particular argument that where you're suggesting the warrant, I think M5 and M8 were overbroad.
Yes.
Do you agree that argument wasn't raised before the district court? You're advancing that argument as a new issue on appeal, but arguing that an exception should apply, warranting our review for the first time on appeal?
Well, and that's what the court's gonna have to decide. I tried, without being involved in the trial and going through the record and the hearing and the motion, I tried to point out in the reply brief, I think especially after reading the state's brief, where we believe the issues were raised. And with regard to the phones, trial counsel had filed a motion to suppress and then argued that the search warrants authority was exceeded when the cell phones were looked at and then data was retrieved. And then he also alleged a material breach in the chain of custody, and that's in the reply brief. And I stand by the record. I've tried to point out where I believe things were raised, and whether it's sufficient or not, that's what the court has to decide. Or if the exception applies that we asked to consider in the alternative. But with the cell phones, not only are there no specific facts alleged for searching them, but then we don't have any kind of limiting search terms. It's just sees everything that's on it. And then we've got these transcripts where we've got witnesses who are testifying against the Hillard saying whose voice it is, who's saying what, and the parts that are inaudible. And just instead of if a court reporter might take it down, then she might just say parts that are inaudible. And if that were played for the jury and that transcript were given to the jury, then they might just read inaudible. But here you've got a transcript that's being given to them, and it's being explained by these witnesses, this was when this happened, and this is who said what. That's what makes it prejudicial, is that the witnesses helped identify who and what was being said by the voices on the recordings. And so that to me is what also makes the seizures of the phone significant, is just that then there was a transcript prepared. Then we've got witnesses saying what was on the transcript. We don't even have a certified court reporter doing this transcript. And then we've got Lawrence Police Department, and they're enhancing it. And we don't know what parts were enhanced. And so the search of the iPhones, I think, is significant. And that's it's significant because the credibility of both of those witnesses were at issue. And so for them to be identifying what's being said on those recordings and then have it be presented to the jury, I think trial counsel had made the argument that because there was loud screaming on the recordings, that the jury might be persuaded, to just go to the transcript and read that because it's easier on the ears. Now, I know there was a cautionary instruction that was given that said that if anything conflicts, you go to the recording itself. But that recording is hard to hear. So I do think there may be a tendency for people to focus on a transcript that maybe is easier to manage for them. But in any way, it gives the jury conflicting information, and information that was determined what it was by witnesses that were testifying against the Hillards.
Are there any other questions? Thank you, Ms. Miller.
Thank you.
Mr. Gillette?
Thank you, Chief Justice, and may it please the court. I want to start off just by pointing out that this is now the third appeal amongst a group of defendants who kidnapped, tortured, and ultimately murdered Scotty Goodpaster here in Sedgwick County. And I want to begin my presentation today here by discussing factual inaccuracies and try to clarify some of the claims that have been made based on the record. To begin with, the first argument that I heard today was a challenge to the entry to the residence on Meridian Street there in Valley Center. I would put to this court that from the trial court till now, I understand that defense counsel is trying to portray the 911 call from Ms. Grunder in a light most favorable to the defendant. Unfortunately, that is not accurate when one actually does consider that 911 call. As was even included specifically in search warrant M1, Ms. Grunder described, she called at approximately 10:45 in the morning. She saw her son, Jeff Hillard, another white male, two females beat up a man on the ground outside the house. A black male then came out of the garage on the premises with a roll of tape. The man who was beaten up was then put into a wagon and then put into the bed of a white Chevy pickup with a damaged right front bumper. The pickup was driven by Jeff Hillard. That was the extent of Ms. Grunder's call that was included in search warrant M1. And there's actually a lot more to her call. The call is part of the record. At no point does Ms. Grunder say everyone involved left. What is clear is not only that she didn't say that, but she did say that somebody that was involved in this came from the house. They came out of the attached garage. So in addition to Ms. Grunder's call, what else did these officers know at the time they conducted their initial sweep? They also had a call from Craig Bright that the defendant and some other people, perhaps with a body, were at his house, and they were specifically looking for bleach to clean something up. Jeff, the defendant, had blood on his hands. He makes remarks about this is about the girls. Nobody's seen the girls. No one has seen the Hillard's girls. Craig Bright's house is very nearby. I think State's Exhibit 202 depicts that. It's just a little further east into Sedgwick County from where the torture occurred there near Valley Center. And Craig Bright has this interaction. He's able to call 911 by approximately 11 o'clock in the morning, so less than 15 minutes has transcribed. We know that officers arrived on scene at the Valley Center home at approximately 11:30, sometime just not terribly long before then, because it's at that point that the chief of police for Valley Center makes the scene and immediately calls the detective for Valley Center Police Department to come out there. He arrives on scene at 11:53. The entry to the residence doesn't happen until 11:56. What else do we know from that timeline? We still don't know where the defendant is. We don't know where this person that had been loaded into the truck has gone. We do know that there's been enough time for the defendant to have gone to his ex-brother-in-law's house, potentially come back, although the truck is not on the scene. We don't know who owns the truck. I don't believe that Ms. Grunder stated that her son owned the truck, just that he was driving it. We also don't know where all of these people are, including the girls, these two children that the defendant was apparently referring to when he talked to Craig Bright. So officers were unequivocal from the get-go that they were there. They were pounding on the door, at the front door, trying to get in, trying to get some response. They received no response, despite it being readily apparent that they were there pounding on the door. I don't think that there is any reasonable way. Oh, well, actually, let me back up. There are also two scenes that are readily apparent once they get to the Valley Center home. There's a bloody scene in the yard in the driveway between the home and one of the outbuildings. They also conducted an initial sweep of that outbuilding, and inside there found a bloody scene where there was blood all over a chair, where it was apparent someone had been restrained in that chair with electrical cord, zip ties, things of that sort. The defendant at no point ever challenged the sweep to that outbuilding. So that is not before this court. And it is something that was known to these officers when they were pounding on the door trying to get a response. So when they conducted their initial sweep of this home, the state posits, as it did below, this was absolutely justified under the emergency exception. This is exactly the kind of scenario that we would expect to see the emergency exception utilized in, because they had an objectively reasonable basis to believe that someone inside is seriously injured or threatened with serious injury. And two, the manner and scope of which they entered and did their search was reasonable. So what did they do? They eventually break in, they go in, they only look for people. They find Heidi Hillard, who ends up being a co-defendant and probably the main driving force behind all of this. And they find SS, who it turns out was another victim. And they find the two young girls in the house. They get them out, they secure the house, then they start working and waiting for warrants while trying to figure some things out. While they're waiting for the first search warrant, I heard a comment, there was a comment today. I don't know that this has actually ever been directly challenged below or articulately, even in this current appeal, but officers go into the attached garage while they're waiting on the first search warrant. And this took about 3 to 4 hours. In that window, they go in the garage because they see cameras outside. They try to go look at a monitor that they can see in the garage. No evidence is ever admitted at trial that resulted from this peek. I don't know what else I can say about that. There was no evidence admitted at trial about what they went in there to try to peek at, other than they didn't see anything. Then when the officers were lawfully present, executing the initial search warrant, they went into the master bedroom at the Hillard residence. I posited in my brief, and I will stand on that for the issue of preservation. I don't think that this claim is preserved either with a timely and specific objection below or with adequate briefing here on appeal. Specifically on appeal, the argument has shifted away from the general and vague argument that was made below. We would posit again that the emergency exception, as well as probable cause and exigent circumstances, justified this. They did manipulate that device. They were able to look and see a few things that corroborated what Ms. Grunder had called 911 about. And so they don't continue searching right then. They secured the equipment. They unplug it, take it with them, and then they await subsequent search warrants. If I could I apologize, I'll back up real quick to the house sweep. And I believe that probable cause plus exigent circumstances also applied there. I set that forth in my brief. If there are no questions on that, I'll just keep moving. As far as this bedroom peek, there are alternative findings made by the district court. One was inevitable discovery, that you basically excise from search warrants M3 and M4 this peek, and there is still probable cause based on the four corners of those warrants to have searched those DVRs. That's not challenged at any point. Two, the attenuation doctrine applies, and I'll stand on my brief for the analysis of that. Given the time, the search warrant, the no flagrancy in their initial cursory look, et cetera. I guess I will spend the rest of my time talking about the phone and answering any questions that this court has.
Counsel,
Yep.
I do have a question about the venue instruction.
Okay.
If you don't mind, is now a good time to jump to that?
It's as good as any.
Okay. So we have instruction number 4, which is the elements instruction, that the last element specifies that the act had to occur in Sedgwick County. And then we have instruction 50, which sort of incorporates the other statutory venue provisions. How is this not confusing to a jury, especially with language that instructs the jury that the prosecution may be in any county in which any of such acts occur?
I would say that this is not confusing to any jury based on, I would even cite the defendant's own authority right back to them. The Rivera case analyzed a similar situation and found that juries have to read their instructions as a whole. And when they do that, this type of scenario is not confusing. The bottom line was that an element, one of the elements of instruction based on PIC is said that the events happened in Sedgwick County. The court then later provided this supplemental instruction that specifically, I would also point out that this only applied to the premeditated murder, the felony murder, and the rape of SS, that these events are the only counts that instruction applied to. It was only those events that there was some indication that they happened in transit. And I think that this makes it clear to the jury that the quote unquote, the element of a crime being a venue, which isn't a true element of the crime, that can be satisfied if this crime is either A, all committed in Sedgwick County, B, happens while a vehicle was traveling through Sedgwick County, or C, that the requisite acts for the commission of these offenses, at least some of them occurred here. And I don't think that any reasonable juror would be confused by that.
I thought in Rivera, and certainly our case and our opinion in Robinson, found similar instructions to be confusing enough to constitute error, but ultimately were harmless so long as the evidence was sufficient to establish venue in the location where the prosecution occurred.
And I think that's fair. I would simply push back on the finding that this would be confusing. I don't know how a jury, when we presume that they read all of their instructions, we are required to interpret those instructions as a whole. I don't know how a juror could find this confusing. And I don't think that this was argued in any kind of a confusing manner. But even if there were some potential confusion here, again, based on Rivera and as Justice Wall, you point out, this court's precedent as well, it's harmless. And I think the quote from Pyle is telling as to why, and that's because a murderer should not escape punishment simply because the exact place of his crime is concealed. That is not, that's not the way things are supposed to work. I'll spend some time on the cell phone issue. The first thing I would point out is that defendant's primary issue about limiting the cell phone search warrants is not properly before this court. It was absolutely not raised below. It is a new issue that was raised on appeal, and in her opening brief, opposing counsel did not cite any exception that would allow her to make such a new argument. She's attempted to do so in a reply brief. I do not believe that is sufficient. There are several things just rolled up in this argument and in the opening briefs, and the state has done its best to try to address each of the statements that have been made, the passing claims that are made based on sometimes just single sentences. But I would also point out the objections to the first attempt to unlock was not preserved with a timely and specific objection below. There was no challenge at all to the fact that in the initial warrant M1, the affiant was clear that he's aware cell phones can be used to monitor and record images and video from home security systems which were present. Those phones were then seized. The chain of custody, the test for that is a reasonable certainty that the object has not been materially altered. There's no indication that these were ever materially altered. The objection below was, I guess, chain of custody and what could best be described as a vague confrontation or due process argument that had no support in the law. The court likened it to a consumption of evidence, but there's no indication that would draw a parallel between what happened with these phones and the consumption of evidence. There's no indication that Cellbrite made any material alterations to these phones. All they did was use technology, provide a passcode to access them. And then that access was granted via a subsequent search warrant, M8. And it is clear what Knoll was looking for. Detective Knoll, when he was going in to look, that it was clear that the phones were used during these crimes, specifically to record some of the torture that was occurring. The items to be looked for were images, video files, audio files, documents, and communications. That's it. Then as far as the enhancement of the hotel recording, I'll just briefly touch on that in the transcripts. It really wasn't enhanced. Detective Knoll was clear, and both copies were admitted to the jury for their consideration. They tried to use Lawrence Police Department to enhance the audio to make things a little more clear by just dropping the background noise. That didn't get them anywhere. Likewise, the use of the transcripts, those were appropriately utilized in this case. They were not admitted as evidence. The jury was instructed accordingly. and they were merely demonstrative exhibits that the district court did not abuse its discretion in utilizing. If I may have just one moment, Chief Justice Lugert, to sum up.
Yes, you may.
The state has heard nothing today that would merit any kind of a reversal in this case. The arguments that have been made are largely based on fallacies that were crafted below in an attempt to view the evidence in the light most favorable to the defendant. They do not support reversal when the evidence is appropriately reviewed and considered throughout this appeal. If there are no other questions, I thank this court for its time. I would ask that the convictions and sentence be upheld.
No questions. Thank you, Mr. Gillette. Ms. Miller, you reserve 2 minutes.
Sure. With regard to the suppression issues on the iPhones, to us, that's significant, just because there was no limitation on what was collected from the phones. There wasn't probable cause in the search warrants to support searching the phones. Then there was a 10-month delay in sending the phones to this private company. And I'm not sure we even know what was enhanced on the videos or on the audio files from those phones, if that was ever stated or not. But it's our contention that the issues were raised sufficiently for your consideration. And you can look and see in our reply brief, where we believe it was sufficiently raised, but that they were not supported by probable cause, and they weren't limited in scope either. And then on the events with Ms. Grunder, I understand the state's position is considering Mr. Bright's call, but you do have to consider what's alleged by the applicant. That's what the judge considers is what's alleged. So if they had more information, then they might have. But we look at what the applicant alleges to support the warrant. And that would be all from the appellant. If there's any questions.
Are there any questions? Okay, thank you, counsel, to both of you for your arguments this morning. The court will take this matter under advisement.
Thank you.
Thank you.
Thank you. Now transition to the next case on the morning docket. Mr. Stratton, we're not seeing your video. Okay. There we are. So with that, I'll welcome both of you and ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to call this case.
Thank you, Your Honor. May it please the court. The second case for the 11 a.m. docket is appeal number 124397 in the matter of Michael N. Spiegel, matter and attorney discipline. The Office of Disciplinary Administrator has reserved 2 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Would you please state your appearances?
May it please the court, Tom Stratton appearing for the Disciplinary Administrator's Office, ready to proceed.
May it please the court, Michael Spiegel appearing as respondent pro se.
Thank you. Mr. Stratton, you may begin your argument.
Thank you. The respondent in this case, Mr. Spiegel, was admitted to the practice of law in Missouri in 2000 and in Kansas in 2002. On June 8, 2020, the Office of the Disciplinary Administrator received a letter from him in which he self-reported receipt of a suspension of his license in Missouri. He provided a March 17, 2020 order of the Supreme Court of Missouri suspending his license indefinitely and requiring 6 months from the date of the order before a petition for reinstatement would be entertained. An October 26, 2021 Missouri Supreme Court order was provided by Mr. Spiegel to me around the first of the year and I found it on the Missouri Court's website online. It says that Mr. Spiegel is reinstated as a member of the Missouri Bar in good standing. The case is before the court today on a summary submission agreement pursuant to Court Rule 223. My comments today are made in support of this agreement, although at a certain point you may wonder, but they are. The agreement was approved September 21 of 2021 by the chair of the Kansas Board for Discipline of Attorneys. It contains the parties' joint recommendation that the respondent be suspended from practice for 1 year and an additional recommendation that he be required to undergo a reinstatement hearing pursuant to Court Rule 232 prior to his reinstatement. The chair of the Board of Discipline considered, and now the court has under its consideration, the facts underlying the Missouri suspension and the Kansas summary submission. The facts are addressed in an information that was filed by the Missouri Chief Disciplinary Counsel in Missouri, and that's in the record, and the Missouri Disciplinary Hearing Panel decision that was considered by the Supreme Court in Missouri when it entered its suspension order. Also, those are in the record. The court in Missouri did deviate some from the hearing panel's discipline recommendations. The order states respondent violated 3 rules, and I'll just give the Kansas equivalents, which are 1.7A2, which says, as it applies here, that a lawyer shall not represent a client if the representation involves a current conflict of interest, which exists if there's a substantial risk that the representation will be materially limited by a personal interest of the lawyer. And then Kansas Rule 1.8K, which says a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship was established. And finally, 8.4D, which says that it's professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Pursuant to Court Rule 221C2, the Missouri Supreme Court's discipline of the respondent for violating its rules is prima facie evidence of the commission of the conduct. The court may wonder why it has been presented with a submission seeking a 1-year suspension when the indefinite suspension in Missouri ultimately lasted over 19 months. The disciplinary administrator suggests a 1-year suspension with a requirement for a reinstatement hearing creates a roughly comparable period of suspension, especially when additional facts are considered. The Kansas suspension carries a financial requirement. The Kansas discipline will be in addition to the suspension that respondents already served in Missouri. The court will, of course, be deciding whether a comparable period of suspension should be the appropriate discipline in Kansas. In its order, the Missouri court provides an outline form how discipline was determined in Mr. Spiegel's case. Court says it considered its findings, its previous decisions, the ABA standards for lawyer discipline, and aggravating and mitigating circumstances, but the decision provided no further explanation. Now, these categories for consideration, I'm sure, will be the categories considered by this court. And because the written record contains no detail regarding how the Missouri court made its determination, I'd like to briefly fill out the outline provided by the Missouri court as it would apply in Kansas.
Mr. Stratton, I have one question, and it's probably because it's so new, this summary submission agreement. It appears that, I'm pulling it up right now, that under Rule 223, that the summary submission should include any applicable aggravating and mitigating circumstances. And I didn't know whether what you submitted, just we should infer from that what the aggravating and mitigating factors are, or whether they need to be set forth with the label of that.
Thank you, Justice Standridge. I would suggest that because there was no determination in Missouri, that's something that is now available for the court to decide. I recognize the rule that you just recited, but it may have been presumptuous for us to supply our own view of that. I'd now like to present the court with what our view is so that it can be considered by the court and determined by the court.
Now, is that a joint? Is because what you submitted was, like a stipulation, but because the agreement between the disciplinary administrator and respondent to proceed by summary submission must be in writing and contain the following, and then it's 1, 2, and then as part of 2D, aggravating and mitigating, and I know you're going to discuss it here, and I just wondered as a procedural matter whether it needs to be part of the summary submission so that respondent is also acknowledging that those are aggravating and mitigating.
I recognize the court's concern and the fact that it was not included in written form in the agreement that was presented to the court. I would suggest that there should be no dispute regarding these matters. And in fact, I was prepared to address mitigation in addition to aggravation so that a fair picture could be provided for the court.
Thank you.
Thank you. With the court's permission, I'll proceed and include those considerations. And then, of course, the court will decide whether to accept or reject them. For previous decisions involving lawyer sexual misconduct, I'd suggest that in Kansas, In re Wishman, 290 Kansas 70, a 2010 case, and In re Pattison, 280 Kansas 349, a 2005 case, have some similarities to this case. Both cases resulted in 1-year suspensions. Although the cases likewise have obvious differences from each other and from this case, when considered in the context of this sample of 1-year suspension precedents, it's suggested that this case before the court is not an outlier. The ABA standards for lawyer discipline provide guidance, although Mr. Spiegel's actions need to be considered for the proper application of these standards. For purposes of this argument in support of the summary submission, I'll refer only briefly to the facts, and in addition, again refer the court to the Missouri information and the hearing panel decision exhibits, which are before the court. Addressing the applicable ABA standards in summary form, I'd suggest that under factors to be considered in imposing sanctions, the 3.0 general factors are as follows. The duty violated was to the client who deserved representation that was not complicated by the sexual relationship. The duty violated was also to the legal system. Mr. Spiegel essentially became a witness at a minimum when he commenced a sexual relationship with his client while representing her in a child custody matter. Regarding mental state, it is suggested that Mr. Spiegel acted intentionally in the lead up to the establishment of a sexual relationship with his client. And in addition, he knowingly violated his duty to the client, the legal profession, and the public, and to maintain his personal integrity. And that's Wishman at page 74. Regarding injury, Mr. Spiegel's client was potentially injured by his inability to give advice that was unclouded by his personal feelings and by the absence of his advocacy on her behalf when he withdrew from representation after the sexual relationship ended. The violation of 3 disciplinary rules means there were multiple offenses. That's Wishman at page 74. I will suggest aggravation and mitigation in a moment. And I'd ask that my colleagues that are communicating by a form that causes beeps to please desist, because it could be distracting for the court. Under 4.0 violations of duties owed to clients, it suggested guidance can be found at 4.32. Suspension is generally appropriate when a lawyer knows of a conflict of interest and does not fully disclose to a client the possible effect of that conflict and causes injury or potential injury to a client. Under 6.0 violations of duties owed to the legal system, 6.22 is applicable. It says suspension is generally appropriate when a lawyer knows that he or she is violating a court order or rule, causes injury or potential injury to a client or a party, causes interference or potential interference with a legal proceeding. Among the aggravating factors that should be considered are the selfish motive of respondent, and his misconduct stretched over a period of 5 to 8 months during his representation, which is in the record at the information and the Missouri hearing panel decision. It further supports findings of pattern of misconduct, vulnerability of the victim. That's consistent with the finding in Pattison. In addition, during the representation, the respondent had substantial experience in the practice of law, having been a member of the Missouri Bar for 13 years. And as I alluded to earlier, I do have comments to make in support of mitigation, which is an unusual position for the disciplinary administrator to take, but support of the summary submission, I feel obliged. And accordingly, I'd suggest, in addition to any remarks that respondent may make regarding mitigation, that the record supports a finding of an absence of a prior disciplinary record. The respondent has cooperated during our case and made full and free acknowledgement of his transgressions. In addition, his previous good character and reputation in the community is shown by his exhibits. And finally, as previously mentioned, there have been other penalties or sanctions, that being the Missouri suspension order. Any other arguments of mitigation, I'll leave to the respondent. I'd suggest that these comments would support the endorsement of the 1-year suspension that has been put before the court by the agreement of the parties, and that the reinstatement hearing should also be required. Thank you. Court has any
Questions? I don't see any questions. Mr. Spiegel. Mr. Spiegel, you're muted.
May it please the court, Your Honor, I apologize about that.
Okay.
I've heard the arguments and the statements of Mr. Stratton. I have worked with Mr. Stratton since the beginning of this case, realizing we are on obviously separate sides of the action. I've been forthcoming with all of the information I have in this matter. I've provided everything that Mr. Stratton has requested. I did self-report on this case. Obviously, I believe the justices are all aware of the discipline that's been imposed in Missouri. I was served out the length of my suspension and have now been reinstated in the state of Missouri. As part of that suspension, I was required to take the MPRE exam. Again, I believe I have included that as one of my exhibits. I passed that. I have gone through the reinstatement process. I will certainly hold out to you that it has been a very humbling matter that I don't ever wish to repeat again. I made a severe transgression in approximately 2013, and I've been dealing with the consequences of my choice for roughly 8 years at this point. And I believe today we may be at the final step to conclude the matter fully. I've apologized for my actions to the victim in my case. I believe that was done formally through the reinstatement process, through the brief that I filed there. Obviously, there's been no direct contact between myself and her. There's been some financial ramifications, obviously, that came through. There had been a civil suit that had been involved on the Missouri side, and that was settled confidentially with to everybody's satisfaction. I don't know any other way, and I don't want it to sound hollow when I say this, but I deeply apologize for my actions. I value my my ability to practice law and to continue to practice law. I understand that what I have done is something that will never be repeated by myself, and I don't anticipate I'll ever be before you again on any matter. I've been practicing for roughly 20 years. I've not had any discipline by the Kansas court or the Missouri court previously. I, again, don't anticipate that I will in the future. I have just started recently rebuilding my law practice in Missouri. Obviously, that came to a stop very quickly, and I had to go through the procedures in Missouri to advise each and every one of my clients that I had to withdraw their cases from their cases and the reasons why. Again, never having had anything similar to this or any discipline with any court before. That was very humbling. I've had to explain to judges on the Missouri side where I practice predominantly, to my friends and also to my family, what happened. I come from a family where my father was a judge for 30 plus years, and I had to explain to him what had occurred and that I was going to be suspended from practice as well. I have other members of my family who are also in the legal realm, and obviously this was not a fun conversation to have with any of them. It was very embarrassing personally. It was embarrassing professionally. It was something, again, that I know I don't personally know any of the justices before me personally, but I think anybody who knows me knows I will not be here and I will not be in this position again. As I've worked through this process, Mr. Stratton has contacted me on a number of times. I have contacted him a number of times. He has been nothing but a gentleman to work with in these matters, realizing we are on opposite sides of the case. Again, my apologies to I'm going to refer to as victim in this case. My apologies to the court and my apologies to my family.
Mr. Spiegel, I just have one question. Did you practice in Kansas during your Missouri suspension?
Justice Standards, I did not. I have, when I became licensed in Kansas, I was actually the prosecutor in the state of Missouri full-time, and I was immediately inactive. When my suspension did come through, I didn't make any attempt to activate or to pursue my Kansas license because I knew that would cause additional problems.
Thank you.
Anything else? Mr. Spiegel, did you have any objections to the aggravating or mitigating circumstances that Mr. Stratton's laid out for us?
No, Madam Chief Justice, I do not.
Anything else?
Nothing further by me, Your Honor.
Thank you both. Thank you for your arguments. Mr. Stratton, you reserve 2 minutes.
Yes, I just feel obliged to say that Mr. Spiegel's demeanor today, the cooperation that it shows and the remorse that it shows is consistent with the interactions I've had with him since this case commenced.
Thank you. Any further questions? Thank you to both of you for your arguments today. The court will take this matter under advisement to issue a written decision. With that, the court is now in recess until 9 a.m. tomorrow.